Hi, you are listening to the Conflict and Development in Africa podcast. This podcast is for policymakers, governments, researchers, students, businesses, and anyone that is interested in conflict and development issues in Africa. On this podcast, we hear from experts from across Africa and the world. Your host, Dr. Michael Nwankpa, will ask the questions you would want answers to. Michael Nwankpa has an extensive experience spanning over a decade studying, researching, writing, and consulting on conflict and development issues in Africa.
Hello and welcome to another episode of the Conflicts and Development in Africa podcast. I am your host, Dr. Michael Nwankpa. Today we're going to be discussing the topic African regional courts, a viable alternative to the International Criminal Court. I'm joined by a very special guest, Editimfon Ikpat. Ms. Ikpat is an international legal professional and the author of the book Chapter is an African Regional Court, a viable alternative to the International Criminal Court. Editimfon, I'm pleased to have you join me today, and I look forward to our conversation.
Happy to be here. It's been a long time coming.
Yeah, brilliant. It's actually been a long time. We've scheduled this for a couple of months now, so I'm glad to finally have you join us. So let me start off by saying, so I think it was on June 27, 2014, when the AU Assembly of Head of States and Governments adopted the Malabo Protocol that empowered the African justice and human rights with international criminal jurisdiction. So I think this effectively bettered the concept or proposal of an African regional court. So can you take us through this process, including why an African regional court is deemed necessary?
Okay, thank you for the question. So in 2014, of course, there was the adoption of the Malabo Protocol, bringing into the existence of an international criminal jurisdiction in the African Court of Justice and Human Rights, the proposed court actually, because up till now is not yet in force. So this has kind of made a new wave and how we have seen the international crime scene, because it has only had the international actors and domestic actors, prosecuting international crimes. So it's been a build up till now, because when the protocol was adopted, there were a lot of speculations, about the fact that the African continent is having a throwback against the ICC in the fact that it has been prosecuting its leaders. So of course, this has been a contributing factor, but I think the African court, the African continent, has had this idea of having international crimes prosecuted on the continent, because far back before the adoption of the Rome Statute, there has been a position by Guinea that in order to look at the human rights violations that has taken place in the continent over time, having this background of colonization, which we cannot depart from because it's in our history, we should have courts that have the authority to try international crimes. But as at that point, that view wasn't deemed necessary. It felt that, okay, it's too immature at that point because we were still trying to grapple on who we are as a continent, so that in the future, it should be proposed through a protocol to add to what we have. So we can say that there is this background already before the Malabo Protocol has come into place. So I think that it's been like a roller coaster of events, looking at South Africa, looking at Rwanda, looking at Central African Republic and other African countries who have gone through a lot of conflict and are still going through, as we are speaking, conflict. So I think that has been a pathway that in as much as we have the ICC, and truth be told, the ICC is further depart far from where it's happening, because it's here in Europe, is in Netherlands, is in Den Haag, and we have 55 countries, so including the African continent. So we have this diverse group of people in a particular region, and we just have one court sitting and trying to fight all of this. If you go back and look at South Africa, you have they use the TRC in a way that worked for them. If you go and see Rwanda, although they had the ICC, the series with a court, which is like the domestic way that worked for those that were still not tried by the ICC. Have Chad state with the hybrid court, and then we also have the specialized jurisdiction that was proposed, in Central African Republic. So when you look at bits and pieces, we cannot depart from the truth that we have to have this in place in Africa. So that's where I think that this has been seen as a building block onto how we want to go into the academical step by step of all the protocols, of all the AU declarations. It's going to take a very long time. I'm just giving an overview of what has been done on paper, because I think the AU is really progressive on paper. Let's be realistic. If you look at a lot of the declarations during their AU conventions, you will see they have a very future thinking and dynamic way of looking at things and proposing solutions. But now the problem we have is implementation of those solutions. Because even when we were trying to indict and prosecute His and Habre, they had the eminent jurists come together and propose different solutions, and they still said that we need original criminal jurisdiction, and if the already proposed Malaba Protocol can be ratified and brought into force, then this is going to help a whole lot. So there has been a lot of works up till now. We would not, in summary, we will not detach the fact that the African court is trying to, I won't say independent, but trying to create its own identity in a sphere where it's seen as mainly European, because there is this notion that the National Criminal Law is mainly an European thing. If you look at the Americas, they are far detached from it. Yeah. So I don't know whether it's because of the proximity of the European continent and the African continent that that brings us together, and the fact that we have this mutual relationship of the EU and the AU in some affiliations. So of course that has been one of the major, and of course a lot of critics have come from there, that the AU doesn't like how the ICC is just on its neck trying to prosecute its leaders. But I think if you look at it, it's been how what's the right word to use? It's been a springboard. It's been a springboard, because if you don't do your stuff, other people will get it done for you.
Exactly.
So seeing that it's been done by the Europeans, I think they think it's affecting the identity as independent, first of all, sovereign countries, and as a region, as a continent. They are being submerged back into the idea of neocolonialism. So that has brought about the need, to adopt the Malaba Protocol. But will it ever come into force is a big question we are all waiting for to be answered.
Yeah, very interesting. It's very interesting to see that there's been reservation even before the ICC and all of this. But there seems to be a paradox, which you've clearly we clearly like hinted at in your answer. The paradox is the motivation behind the African regional courts. Is it one that is driven by identity, like you already said, covenant and identity, our own kind of? But then again, in your work, you've also pointed out that some of the critique of this is saying there seems to be no distinction between the ICCs molded on the ICC. There seems to be no much difference. So if it's identity that is the driving force, we're not getting it. So what's the whole point of having a regional court that is molded, that is basically everything the ICC is like, it's just transposed or extrapolated into this. There's no identity in it. So, and I want to relate it to when I had Tradi coming and in my own work as well. We've seen where like Riley pointed out, the African continent, African leaders have seen ICC has been biased towards African leaders in terms of its prosecution. But also we've seen where some African governments have also manipulated or used this. So I look at Nigeria, for instance, and the Boko Haram. Nigeria was supporting the ICC prosecution investigation, but once they were, once they were fingered in terms of being held responsible as well, they started saying, "Oh, ICC, it's no." So once it favors them, they are for ICC. Once it doesn't favor them, they're not for ICC. So do you see where the problem of it coming into fruition could be also it becoming a tool in the hands of African leaders or governments?
Okay. Thank you for your question. But I would take the last part before I go further. The fact that you use example of Nigeria, being one of the advocates of the ICC, and when he had to come to the Boko Haram case, they were like, okay, this is where we draw the line. We also have the same issue with Kenya when Kenyatta was, indicted. I think Kenya was one of the main, advocate also of ICC. And when Kenyatta was indicted, they were like, okay, this is where we also draw the line. So I think in our individual sphere, we can say this is the idea of international criminal law and bringing people into accountability and justice is one too good, is one that is really, really everybody accepted, because I don't know if you've ever picked up a transcript of the case laws and read through the testimonies of the witnesses. Man, it's mind-blowing in a negative way. It can be crippling. And of course, we want those who had a hand in this to be brought into justice. But when it comes to your doorstep, how open are you, to take it in and be unbiased that, yes, I know I am for this and it's come to my doorstep, I can open up the door and let justice come in. So now we have this setback because, like realistic, in most of international crimes committed, we cannot remove the involvement 100% of the government in one way or the other, because in most cases it's always maybe an uprising, or there is something about post-British and emancipation of the people from. We have seen how the African leaders are in most cases from this tyranny or dictatorship. So in one way or the other, we see that there is this pushback because the African leaders are also involved in to an extent of the occurrence or happening of these crimes in the individual country. So now the question that if this court comes into fruition, will it be a weapon in the hands of the
I'm kind of losing your beat in terms of your mic or something. I don't know.
Can you hear me now?
Yeah, I can hear you now. So maybe you're standing like for a distance away from the mic. Yeah, go on.
Okay. So I'm now taking up the question that you asked, that can this court, if ever brought into fruition, become a weapon in the hands of our African leaders? And it can be a yes, and it can also be a no. Like I say, it depends on who is opening the door, who is at the door of justice of each state, or sorry, we use state in the international, so of each country. So like you can have a governing power that is for it opens the door, and you can have a governing power that is against it and closes the door. But the thing is that once you open the door, you don't know how many worms are in your cans. So there's some you don't want to be seen, and there's some you actually want to be seen. You get, so you can't necessarily pick and choose. Once the door is open and justice comes in, let's use the justice lady. She's blindfolded. She's not gonna pick and choose, like, okay, I'm gonna try war crimes, I'm gonna leave aggression. She's gonna pick every single thing, and that's what justice is all about. There is no one left behind. So I think it's going to be a weapon, yes, because they're going to pick and choose. And if you see the immunity clause also, it already gives you like heads up, like, okay, this is it. I'm the big guy. I've done this. I can't be touched. This is it. And it won't be far-fetched if when you step down or before you step down, you leave the country to where you cannot be extradited. So already that shows you that it can be a weapon, but it might not be a weapon where we have someone who says, okay, this mostly happens when you have an incoming government, having to do this chase over the outgoing government. So, this is something we see every day. When the new government comes in, it tries to backlash the outgoing government and see itself. So, and truth be told, this is not something that is specific to the African continent. This is politics we're talking about. And we cannot detach international crimes from politics. It's I would say it's a form of accountability that is highly politicized. Even in the way justice is being brought about is still political. Because tell me, already you have the notion of most responsible. So you have responsibility, all right, of people who have committed this crime. But when you look at the list of people, you then pick who is most responsible. So you leave the other people who don't fall under that category of most responsible. That's already been political, because you're going to pick and choose. And then when you pick up who is most responsible, you still have to pick and choose, even in that collection, because you know what? We are looking at resources. International crime is really, really expensive. Its justice is really expensive. If you look at domestic crime, is the state against this murderer, or is the state against X or Y? But when you look at international crimes, it's not just the state. Is the people who have been affected. These are the victims and people who live with these victims, who see the traumas that they go through. That is one. Then you then see the judges who are going to sit and adjudicate on these cases. That's two. You then see the witnesses who are sometimes have to be flown in or brought back, and then you still have this witness protection. That's three. You still have to see people who are going to transcribe these testimonies, because sometimes those who come into witness can't speak English, because that is the lingua franca for the court, or sometimes French. So you need people, and we both know that Africa has a lot of languages. So imagine you having to go through, and it's not just speaking the language, it's being able to understand and transcribe, which the modern day Africans sometimes can understand, but there are some really, really indigenous dialect that you have to find someone who is actually from that place. So even sourcing for these things. So when you look at all of these things that have to be put into place to prosecute just one count of crime, because it can be a whole lot.
Yeah.
It's really expensive. So that's what I'm saying already. already trying to bring about justice in the international criminal realm it's really expensive, which brings about the political aspect of it, of saying, okay, if we want to spend this much amount of money, who are we going for? Who is going to make the headlines? Who's going to make us look good? Who's going to make it look like we are really actually after the bad guys? So, okay, for example, this big guy in quote, the ICC big guy, Ongwen, who is this child soldier that has been found guilty. But he's also, I did a paper on it. He's also a victim, which has also become a perpetrator. So in that case, how do you go about it? But it had to be tried because he was one of the most responsible, was one of the big guys, and he really made the court look good. So even bringing about justice is still political. So going back to the root of the question, will it be a tool? Yes, because whichever government is bringing the people out to be tried has to look good, has to go for the most responsible, in short, the extreme most responsible. And then if this person is tried, are we really sure that the cost we are bearing is going to, of course, you need a reward at the end of the day. It might not be profit, but really make us look good that we actually brought this guy out. There can be more people, but people's choice also matter. We want this guy to be tried. That's still political. So it's going to be a tool from the political part of it. And no, it's not going to be a tool because one way or the other, some people are getting tried.
So I think you've touched on the next two questions I was going to ask. So you've talked about the approaches. Let's focus on the challenges. So can you add more to it? Is that one of the things that is affecting the court from being established? It's been 10 years now since they adopted the Malabo agreement. I think, first of all, we just assumed, the audience knows what Malabo agreement is. Maybe just summarize the Malabo agreement, and then you look at what are the challenges to achieving these 10 years after then.
Okay, so first of all, we have the African Court of Human Rights, and then we wanted to have the African Court of Justice, and then one of the head of state at the AU convention says, "Oh, why don't we merge the African Court of Human Rights and the African Court of Justice together?" So there's been protocols and protocols. So the Malabo Protocol is just named after where it was signed. It's actually the protocol, the amendment protocol to the protocol of the African Court of Human Rights and Justice. So the Malabo Protocol is just to help us to be sane, because the name of the statute is really long.
It's long.
So, and the Malabo Protocol is straight to the point and says, okay, this is the deal now. We have we have the African Court of Justice, we have the Court of Human Rights, and we're going to have an international chamber in this court. So we're going to have 3 different courts, or in want of a better word, 3 different chambers in the court. So we have 1 court and they have three chambers. One is for human rights violations, of course, that's for the state. One is for Court of Justice, kind of a mimic of the ICJ that we have. I'm sorry for use of what mimic, what a replica.
No, I know, but no, it's a kind of justice, yeah.
And mimic can be like derogatory, if not well understood of the mimic. And then the International Criminal Chamber. So that's what the Malabo Protocol is all about, having all these courts together in one platform. I think it's trying to make it concise as possible. So we just go to one platform and you just pick and choose wherever your case falls. It's really good, instead of having it all over the place. It's really a good idea. Now, the thing is, we have overstretched the court, because I think of it that I'm a secretary at the court.
Okay.
And my day-to-day activity, and you come and you say, okay, I have this case. my human rights was violated again by so states with regards to this. We have a lot of human rights cases every single day, and I'm trying to put it in the docket, trying to find the case number, trying to put it in and find a date, and somebody else comes in. Okay, we there's this dispute between Cameroon and Nigeria for oil. Yes, and then that's one of many, and you're trying to fit it in, and then here comes, okay, there's coup that took place in Mali, that is an overthrow of a government. You're lost.
Yeah.
You're really lost. And then just from the admin stuff, of course, I might not be the only one there, but just from the admin stuff, we already see the amount of workload that is going to come in. And let's not try to deter from the fact that, okay, there are different chambers. There might be different chambers, but the admin system might be one. Because when you come into the court, you have to file things in. And if we're going of the way data is being digitalized now, everything is on screen, it's filed. Maybe you click, you have to see your case number, you click, you have to see your your date and all those stuff. So putting that already in the system is a lot of work before you then start with saying you are located to this chamber, you are located to that chamber. So already the court is overburdened with a lot of case work. So if you want to be realistic, we are in, okay, sorry, I am in Netherlands. The Hague is just an hour, 20 minutes away from me. And I know that the ICC is in a far different building from the ICJ. You do not want to imagine the number of workload those individuals have on a daily, even as they are far apart. So let's imagine that we merge those two buildings into one and say, let's run the show. The ICJ, this chamber, the ICC, this chamber. It's going to be chaotic. We think, okay, because it's international, then they have more case work. But look, it's Africa. It's a continent. We have 55 countries. You don't say you have one human rights per country, human rights violation per country. We have loads of them coming in per country. And you don't say you have one dispute between countries. We have loads of them coming in. And you cannot compare the number of conflicts we have on that continent to the European continent, for example. It's massive. So when we look at all of this in one go, I think we have a lot of workload on our hands. So and then you add the human rights court still in the same building. I'm using the word building as a theoretical.
Yeah, let's say that platform. Yeah.
Yes. What are we trying to achieve?
But then we can then ask then, what is the because it does look at the downside quite outweighs the benefit. It does ask yourself, what is the essence of integrating all of this then, if the capacity is not there?
Yeah, we would not say the downside outweighs the benefit, but the truth is, for everything that happens, you have to look at the negative part of it. Not because we are not aware of the positive, but because we want to shed light on how much the negative can affect the positive. And if care is not taken, the negative can swallow up the positive, that we no longer acknowledge the positive nature of what we're talking about. So it's the idea of the International Criminal Chamber, it's a very good one. I'm one for it. It's a very good one. But it is how we are going about bringing it into fruition that is the problem. And if I can tell you, that is one of the major reasons why it is not in force yet.
Yeah, I want to look at it from my own, from a critical perspective, and also from what you've written. I'm thinking it's more a victory symbolically, and that could that be a reason why is stored in implementation? It's more like a symbolical, or we want to carve out an identity. And from what you were writing in your chapter, talking about issue of proximity, you talk about physical proximity, you talk about psychological proximity. That is, but in actual practice, beyond all of this, it still boils down to what is the differentiation. It's still molded against the ICC. There's no distinction in this, and I think you were talking about a middle ground, and your middle ground, I wanted you to expatiate on it, because the middle ground, from what I see, your conclusion is we should just see it as a supplementary. I don't know if I'm correct. You can correct me if I'm wrong. That is the middle ground you've stated. But do you think that is what the issue is, or is it just the issue of we've not been able to carve out what is the identity? What does it look like in practice? What are we adjudicating?
Yeah.
Because in Africa sense, in my own research and looking at Africa, if you look at African identity, our idea of justice has always been restorative justice. So in South Africa, you look about truth and reconciliation. In Sierra Leone or Senegal, you had similar stuff. So do you think those are the things that are really affecting, rather than issue of this kind of academic debates that we go back and on? I don't know. What do you think?
Yes, I would say yes. It's one of the factors that affect, because if you look at the OAU Charter, it's more communal than individual. That is if you look at it, it's really communal. It even has it talks about family, it talks about community. So it's more about a communal way of living, which is the nature of Africans itself, rather than individualistic. And we have seen that in like I said, the TRC for South Africa, where it was more communal. You've seen it in the Ikpat court, for example, where it was also communal, because it's like, even if we crucify these people, they are from a community. So we still want these people, even if they're accountable, to still be able to be accepted by the community in which against whom they committed these atrocities. So it's like you're hurting me, but I'm still petting you. You're doing me ill, but I'm still forgiving you. So I turn around, I look at the grave of a loved one, but I have no choice than to forgive you because you're my next door neighbor. So and the way the crimes are committed, it's more of it's not a far-fetched, like the individuals committing it are not far-fetched. These are your next door neighbors, these are your friends. It's like saying, all of a sudden we wake up and we say we live together, but because I'm from this ethnic group and I'm against your ethnic group, overnight I just murder you. So that is where we are coming from. It's not that there is a command from somewhere and then the soldiers just come from another angle and then clean up the whole community. No, it is grassroots violence against each other. So that's where it comes from, that we live in a community, so we have to heal the community per se, not the individuals, not the victims. So now the community is the victim, not the individual as the victim. So we are healing the community, not the individual. So as an individual, you're good once the community is good. So that's where it comes from. Now we are departing from that restorative way, because there is this it's retributive, restorative, and then the last one, there's one, I think, is it some competition that comes with it.
So I think mainly, I don't think it's retributive and restorative.
But there is one that has to do with having to compensate. Like how would that be? I have forgotten the word for it. Sorry, it's out of my head now. But because when you do that to the community, you do not compensate the individuals which you have hurt, and then those people still go ahead with that hurt, but the community is restored as a whole. So now we are departing from that point of view and saying, you do this to me, I as an individual, I want to get justice. I do not care about the community now. I care about myself. But now the idea of the Africanness is that we do not see that it's the individuals that make the community. We think it's the community that make the individual. So if the individual is not healed, there is still a way that the same issue can reoccur. Because I, as an individual, I have not been healed from what I have passed through as a member of this community. So now, us moving away from that and saying, you've hurt me, I need you to be punished. Or even if I get nothing from it, but I know that you are being punished as a person now is what we are going for. Now, the idea of the identity of, like the word identity of the African continent in the prosecution of international crimes is that although we have adopted, but hook, line, and sinker with a little sprinkle of differentiation. Because if you take the provisions of genocide, war crimes, crimes against humanity, crimes of aggression, the Malaba Protocol also adds some things that are progressive than the International Criminal Court. Let's say, for example, one of the actus reus of genocide in the Malaba Protocol is rape, which is not in the ICC. It's seen that rape as a means of weapon of war can also be used as means of genocide. How? Because we in the African society practice a patriarchal way of life. So every child born automatically belongs to the father. So if women are being raped, and as a result we have children from that rape, they are no longer in that ethnic group anymore. It now belongs to the other ethnic group. So as a way, you are diminishing this particular ethnic group, and it's a form of genocide. This was in the ICRT case of Akiyesu. I'm giving further interpretation to it. This is not what they said, but they said rape was a weapon in that case. So, excuse me. So already that is a progressive way of thinking that has been included in the Malaba Protocol. Also, the ICC has just 4 crimes. Malaba Protocol has 14 crimes. It adds other crimes that are peculiar to the African continent itself. To mention a few, it has money laundering, bribery and corruption, trafficking of children, illegal trafficking of drugs. It has overthrowing of government, which is the unconstitutional change of government, which is we can even see in present day is still occurring. So apart from the international, I don't know if it's an English word, but the internationalness of these crimes, we still add crimes that are peculiar to the African continent itself. So in a way, those 10 crimes are termed transnational, and we're not arguing. We're not arguing about it, whether it's transnational or it's international or it's regional. We're not arguing. What we have accepted is that these crimes are peculiar to this group of people as a region. And if you would know that even the international crimes of 4 is not all, that's not all the international crimes that they are. If you go far back, piracy was a well-known international, which I think was the earliest international crimes, but it's not in the ICC. So we can see that those 4 crimes are not the stricter sense definition of international crimes in sense. It's just what is applicable to the present day international community. Yeah, there is still proposals for crimes against the environment as international crimes now. We are pushing for that also. So you see that this thing it's dynamic, it's changing over time. I wouldn't be surprised if AI becomes because it's progressive in nature. Is what happens at that point in time that determines the needs of the people at that point in time to prosecute or adjudicate on. And as Africans, we have seen that these things, like for us, war crimes, crimes against humanity, genocide, are not the crimes itself. They are crimes, but they are, I would term them secondary crimes. The primary crimes that bring about these particular crimes, for example, can be change of government, that can bring about uprising, and that leads, to crimes against humanity or war crimes. It can be trafficking. It can be like, and they say it is fundamental to the security of the continent. That is the catchphrase. So we have these primary crimes from which the secondary crimes stem from. So by us prosecuting these crimes that are very identical in our society, which brings rise to these 4 international crimes, I think if we can tackle those 10, we have as well, to an extent, tackled those 4. So that is where our identity comes to play, that we recognize and we see as part of the international body that these are the 4 crimes that have been accepted. Fine. But departing from that, when we come back home as a region, not even domestic, as a region, this is what affects us also. And before we come to the level of international crimes, we are dealing with these transnational crimes that affect us and give rise to international crimes. So that's where our identity comes to play. Now, have we been able to come about or bring about or stamp our identity? We have not been able. Why? Because it's overwhelming. These are a whole lot of crimes. It's overwhelming. So how the international community were able to pick and choose classic 4 in court, and we have 10. I think it's overwhelming.
I was gonna come. So let me come to the last question. Let me wrap it up. But it's gonna be one that have different questions embedded in it. So you let's start off from what you just said about the 4 crimes and I think that also we speak to the cost of the expensive or high cost of prosecuting these crimes, like you've mentioned before, and the need to pick according to to the intellectual minds of the day which ones they find to be the most grievous crimes to treat, and that's how they come about with the 4. But now, if we're talking about also you talked about the transnationality of crimes. We live in an era where we are, no country is an island, is in silo. Any crime committed there has implications and they're interrelated. I talk about those transnationality. So in DRC, for instance, you see the attempted coup, where you see maybe American citizens, being involved in such, and how the African court is going to be able to try other citizens of other countries that have committed crimes on the continent. And I'm just looking at the kind of like conflicts where other citizens, let's say in America, for instance, their citizens, how the court is going to resolve that kind of like there's going to be conflicts of in terms of jurisdiction, let's put it that way. Now, if I then bring it back to what you said in your conclusion, you were talking about the difficulty also in terms of having an African regional court, talking about how many, I don't know now, maybe 30-something African states have signed into the Rome Statute. And you're saying for the African Regional Court to be able to come into fruition and work exclusively as an African, let me read what you said. He said the full replacement of the ICC is only possible when no African state is party to the Rome Statute, and the option of triggering the jurisdiction of ICC pursuant of Article 13B of the Rome Statute is non-existent. So I wanted you to conclude on that note and talk about, one, how would that court, is this possible? Can the African countries really extricate themselves from the Rome Statute to establish this? And how would they deal with transnational crimes or crimes that involve people from other jurisdictions?
Okay, the very foundation of the ICC is a principle of complementarity, wherein the domestic jurisdiction is willing and unable to try the crimes, and then the ICC can step in. So the ICC is dormant. Once the domestic court are doing their stuff, the ICC is really dormant. It can just be seen as a big brother, just going here and there, just spying and supervising how is it going, but it's dormant. So why that was said was, one, and the ICC can only activate that principle where you are a party to the Rome Statute. So where I'm not a party to the Rome Statute, you have no say in my matter, whether I am unwilling or unable to do so. That's my business. I am not a party to you, so you are not a party to my issue. So the line is drawn. So that's why I said, except all the African party members leave the Rome Statute, then the ICC doesn't have a say in the African continent anymore, because it's only when you're a party that you give the ICC that right to come into your door and say, hey, you are not willing or you are not unable to prosecute, and I am here to get that done for you. So open up, I'm here. So, and you already know that there were already this what's it called? It's not proposal, but two, I think Gambia and one other African countries had already put out their interest, like we want to leave the ICC, and that was what brought about the AU withdrawal strategy. That for African countries, if you want to withdraw from the ICC, this is the strategy. So it's already in play. So, like I said, the ICC is it's political. We have to come back to the round table and say, what's going on? If you pull out, that is our credibility being pulled out also. Of course, let's not lie. If you look at the number of party members to the ICC, the African members are a lot. So imagine all of that pulling out. It speaks to the credibility of the ICC as an institution. It speaks to the credibility of the justice you are bringing out of your system, because they keep arguing. Even if you prosecute us as Africans, there are a lot of other countries, having issues and, having things done, but you're not looking there. Why is your lens only on Africa? Are we that bad? Can be bad, but compared to the rest, are we that bad that we are the only ones that need to be scrutinized and judged? That's where that is the bone of contention. If it was cut across, the Americas, EU, Africa, like Asia, like cut across, I don't think our debate would have a lot of value, because it shows that there is this unbiased. But where you are focused on a particular region to the exclusion of others, then it speaks to some bias there. So that's why I said, if the African state as a whole pull out from the Rome Statute, which I am not an adjudicator for. This is just an answer to your question. Then the hands of the ICC are tied with regards to the African continent. I mean, its African member parties. So that's it, because already you have stifled the very existence of the complementary principle of the ICC. So they can no longer step in. And that's what I'm saying. If you are going to withdraw en masse, make sure you have something at home that will bring the same justice that you're withdrawing from, if at all. Because having something is not as bad as having nothing at all. Because we're talking about impunity here.
Yeah. I do agree with you. It's been a wonderful conversation we have. I do agree with you on the benefits of having a regional conflict in terms of proximity, psychological proximity, and having people of your own identity and all of that. But to be honest, I'm not sure. I'm not very optimistic that looking at a couple of leaders that we have, that the African leaders will educate themselves from that, because it would be like something they will use as well for their own to their own advantage, like Nigeria has shown, like some other countries have shown. But it's an interesting time, and I think it's a conversation that is very valid. That Africa should be able to determine its own kind of like justice, what defines as crime and how it wants to punish those that have violated it. So I think it's a very valid conversation to have, and it's an interesting space that I'll looking at, and hopefully we'll bring you up one day and you speak to maybe another 10 years. We'll see what will happen. But it's been an amazing time Editimfon. I really appreciate our conversation. I enjoyed it, and yes, thank you very much for honoring our invitation.
Thank you very much for having me.
All right, you have a lovely day, and I'll see you soon.
Too. Okay.
Bye.
Bye.
Thank you everyone for tuning in this week into this week episode. Join me as usual to thank our guest, Editimfon Ikpat, for her very rich, deep insight into the viability of an African regional court. I implore you to stay tuned for our next episode, and I'll see you until then. Stay blessed.